I'm Lindsay Olivarez. I'm one of the family law attorneys here at Udall Shumway. I'm often asked during consultations, what happens if my spouse and I don't fundamentally disagree about how we should allocate our assets and our debts, or how we should split time with our children? One of the answers is a consent decree, and another is a default decree. Oftentimes I meet with people who say that their spouse has suggested that they simply go through the default process, and I'll define that in a moment, rather than have to get embroiled with both parties in the actual court process. The default process is where one party files and the other party simply sits back and does nothing. It's meant to allow people to get divorced whose other spouse just simply won't participate in the process. Sometimes it's used as a mechanism to come to an agreement, whereby the party who files might say exactly what they're looking for in the petition. The other party doesn't disagree, so they just sit back and relax and let the petitioner take control. I don't recommend this for people who have an agreement for a couple of reasons. One, the petition isn't always as specific as it needs to be in order to flesh out a default decree by the time you go to a hearing on it. While it's true the other party doesn't have to participate, that really puts the burden on the petitioner to ensure that the default decree matches the petition at the time of a hearing. If it doesn't, it could delay the divorce process. The other reason I don't really recommend it is because sort of the opposite of that issue is if you have a petitioning party who maybe isn't as above board as the responding party might like, they might ask for certain things in the petition and then try to slip something different or maybe just slightly different through the default process. And now all of a sudden the responding party is left without much recourse because they've sat back, done nothing, and now they're in the hands of a decree that really they didn't want. So in that situation where you have two parties who really don't disagree, I always recommend that you go the consent decree route. A consent decree is a document that incorporates all of the agreements with respect to property, debt, spousal maintenance, child support, child access, decision-making authority, etc., and boils it down into one cohesive document, or one document plus a property settlement agreement, or plus a parenting plan, depending on the circumstances. And it requires that both parties sign off on it before it's lodged with the judge. The judge then reviews it, makes sure there's no fundamental problems with it, and 9 times out of 10 stamps off on it without any problem. You then get your consent decree in the mail without ever having to set foot in a courtroom, hopefully, within a few days after submitting it to the judge, usually a couple of weeks. That is by far the better protection mechanism for a responding party, because a consent decree cannot be filed with the judge until both parties have reviewed it and executed it. Now, what that means is to avoid someone trying to default against the responding party, that responding party must file a response. They must file a response within 20 days of being served if they were served within Arizona, or 30 days if they were served out of state. But once you file that response, even if all the response says is, I agree to everything in the petition, you've taken it out of the default path. And that means that you can try to reach agreements based on what you do agree to, but you don't have that threat of someone taking the decree out from under you so that things get incorporated that you weren't anticipating. So in any event, if a party comes to me and says, I think we have an agreement, my job isn't to tear apart that agreement and cause a fight. My job is to tell you how to get through the process as amicably as possible without being taken advantage of. And in most cases, that's going to be a consent decree rather than a default decree process.